Hello and welcome to Mains QIP 2020, a series of video lectures where we discussed answers to the questions which have been asked in our mains test series. In this particular video, we are going to take up a question from Indian Polity and Governance. The question for this session is: the Constitution of India grants fundamental rights with one hand and takes them away with other. Critically analyze. The question is of 15 marks and needs to be answered in 250 words. So let us now first go through what to expect from this video. First, we will discuss that why we have taken this particular question, and in that we'll first start by understanding the trend of the UPSC questions in the past. UPSC has also asked a similar question. Then generally we talk about the current relevance as well, but since this is a static topic of polity, UPSC has asked a lot of questions from the static part as well, and hence in these static sections, especially related to constitution, the current relevance is not very important. Then we will understand the decoding of a question, which is very critical. In that, we'll first understand the demand of question, and then we will try to identify the parts of the question. And then finally we will discuss the sample answer, and then we will review our own answer. So if you look at the question, it gets covered under GS2 syllabus of features of Indian Constitution. So the questions from the Indian Constitution have been very diverse. The question have been asked from fundamental rights, DPSPs, fundamental duties, and other parts as well. And hence we have chosen this particular question from the fundamental rights portion, because in the past UPSC has asked, what do you understand by concept freedom of speech and expression? Does it cover hate speech also? Why do films in India stand on a slightly different plane from other expressions? This was asked in 2014. Apart from that, a lot of questions related to fundamental rights have already been asked in UPSC mains examination. So moving on to how to decode this question. As far as identification of parts of question is concerned, if you start the reading of the question, it says that Constitution of India grants fundamental rights with one hand and takes them away with other. Critically analyze. So this question has only one part, but it needs to be answered in such a way that you are able to show that Constitution of India grants fundamental rights and takes them away with another. So this is a question especially chosen to demonstrate the significance of table format of answer writing. So you will see in the sample answer that we'll formulate a table in which we'll write provisions of the fundamental rights on one hand, and then we will write the exceptions in the next column. And then we will demonstrate that how a lot of fundamental rights have been limited because of the exceptions provided in that. As far as key terms are concerned, you have to talk about fundamental rights as well as exceptions. So let us start by first looking at the rights of equality, that is equality before law. Article 14 says that state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So now the question arises that if this particular article has any kind of exception, and the answer is that part 19 of the Constitution of India, in which Article 361 provides protection of President and Governors and Raj Pramukhs, where the President and the Governor shall not be answerable to any court for the exercise and performance of the powers and duty of his office, or for any act done or purporting to be done by him in exercise and performances of those powers and duties. So this is the violation of Article 14, although it is necessary for President and Governor that they be given such protection, but nonetheless it is a violation. Then in clause 2 of Article 361 it says that no criminal proceedings whatsoever shall be instituted or constituted against the President or the governor of a state in any court during his term of office. The clause 3 says no process for the arrest or imprisonment of president or governor of the state shall issue from any court during his term of the office. And then finally the clause 4 says that no civil proceedings in which relief is claimed against the president or governor of a state shall be instituted during his term of office in any court in respect of any act done or purporting to be done by him in his personal capacity, whether before or after he entered upon his office as president or as governor, until the expiration of 2 months next after the notice in writing has been delivered to that person. Which basically means that you cannot directly initiate a civil proceeding against president or the governor. It is important to note here that 2-month notice has to be given to these two sets of people, either president or governor. So these are a broad set of exceptions to the Article 40. Then moving on to Article 15, which is prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. So it makes it very clear that state cannot discriminate against any citizen. And the focus word over here is citizen on grounds only of these. So there can be discrimination against people on various other grounds, but not on these grounds only. But in the same article, if you have a look, Article 15 Clause 6 says, nothing in this article shall prevent the state from making any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in Clause 4 and 5. So the government can enable various kinds of provisions for the advancements of economically weaker sections. Then again, if you go further into third clause of Article 15, nothing in this article shall prevent the state from making any special provision for women and children. So this is an exception because we just saw in the introduction, the state shall not discriminate against any citizens on grounds of sex or gender. And in the third clause it says that nothing in this article shall prevent the state from making any special provision for women. Then clause 4 of Article 15 says that nothing in this article shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. So again the same thing. First, Article 15 says that there is a prohibition on discrimination on grounds of caste, but then it says that discrimination in favor of backward classes of citizens and especially the socially and educationally backward classes or SC/ST is allowed. So although these are positive discrimination and they are desirable as far as our society is concerned, but nonetheless they are an exception to Article 15. Then again in the Article 16, which provides for equality of opportunity in matters of public employment, which says that there shall be equality of opportunity for all citizens in matter relating to employment or appointment to any office under the state. And it prohibits any discrimination as far as citizens are concerned on grounds of religion, race, caste, sex, descent, place of birth, residence, or any of them. But then again, the third clause says that Parliament can make law and allow a particular state or union territory to require residence within that particular state as a condition for an employment or appointment. So a state cannot unilaterally make such an provision. It has to be enacted by the Parliament. So initially the second clause said that place of birth or residence cannot be the basis of discrimination, and then again in the following clauses it said that although the Parliament can make law to enable such a discrimination. And then again clause 4 of Article 16 provides for exception to scheduled caste and scheduled tribes people as far as their reservation in matters of promotion as well as in appointment to the government services are concerned. So this was as far as the rights related to equality is concerned. Let us now move on to right to freedom, under which you know that Article 19 provides wide extensive freedom For example, Article 19A provides right to freedom of speech and expression. B provides for rights to freedom to assemble peaceably and without arms. C provides for associations or unions. D provides freedom of movement, and D provides freedom of residence. And finally, G provides for freedom of practice of profession or any other occupation. But that is Article 19 Clause 1. And just as the Article 19(1) provides for these rights, Article 19 Clause 2, 3, 4, 5 and 6 provide for restrictions. For example, the right to freedom of speech has been provided with a lot of exceptions, which means that on these criteria which are mentioned in the second clause, the freedom of speech can be constrained, which are any law which constrains the freedom of speech on the basis of sovereignty and integrity of India, security of state, friendly relation with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offence, shall not be considered as a violation of Article 19(1). So which means that if the government enacts a law for controlling public order, and in that if it wants to restrict publication of newspapers, it can do that. Similarly, Article 3 provides restriction to free assembly. And again, it puts a lot of conditions, and as far as laws are concerned, such laws which are made in the interest of sovereignty and integrity of India or public order, those laws shall be beyond the scrutiny of judiciary as far as their constraints on freedom of assembly is concerned. Now let's look at Article 22, which provides protection against arrest and detention in certain cases. So Clause 1 although says that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. So this is a very wide freedom. But let's look at the exception. The exceptions are that the clause 1 and 2 conditions do not apply in two cases. One is that a person who for the time being is an enemy alien. So for example, a foreigner who comes from Pakistan will not get this freedom or will not get this protection. So that is okay, that is understandable. But part B says these rights are also not available to any person who is arrested or detained under any law providing for preventive detention. So if police arrests a person under a preventive detention law, then that person loses the right to be informed or loses the right to consult a lawyer or to be defended by a legal practitioner, because that is an exception given in the Article 22. So these were the exceptions which are given with the rights. But there are other exceptions in which the fundamental rights are superseded by some other provisions. For example, Article 31C. As far as the application of Article 39B and C is concerned, if in doing so, Article 14 and 19 are being violated, then that is justifiable. Because Article 31C is all about where 31C comes in, Article 14 and 19 goes out. And finally, the emergency provisions. You know that Article 358 and Article 359 talk about suspension of Article 19 during emergency and suspension of enforcement of rights confirmed by Part 3 during emergencies. Whereas Article 358 says that while a proclamation of emergency declaring that the security of India or any part of the territory thereof is threatened by a war or external aggression, nothing in Article 19 shall restrict the power of the state to make any law or to take any executive action which the state would have otherwise not framed. So for example, if the government wants to restrict the freedom of speech and expression or freedom to assemble, it can easily do so while the emergency is in operation, in the condition where the emergency has been implemented, where the security of India is threatened by war or external aggression. Similarly, Article 359 talks about suspension of the enforcement of the rights confirmed by Part 3 during emergencies. Article 359 talks about suspension of enforcement of the rights confirmed by Part 3 during emergencies. So except the rights conferred by Article 20 and 21, all other rights cannot be enforced. That is the provisions of Article 32 becomes unavailable during the proclamation of emergency if the president has declared so. So these are the wide ranges of exceptions to the fundamental rights which have been provided in our constitution. And that is why it is said that our constitution gives the rights with one hand, whereas it takes away the same rights by the other. So before discussing the sample answer, let us first discuss the structure of the answer. So it will obviously start with introduction in the manner that it introduces the fundamental rights. Then we will talk about provisions of various sections as well as exceptions for those provisions granted in each one of them in the body part. And finally, we will end by substantiating the question statement, which is that indeed the Constitution of India grants fundamental rights with one hand and takes them away with the other. So let us now discuss the answer for the question, the Constitution of India grants fundamental rights with one hand and takes them away with other. Critically analyze. So the introduction part says that fundamental rights as enshrined in part 3 of the Constitution encompass a wide set of rights given to all the citizens and some even to non-citizens. You might have noticed that in fundamental rights, two key terms are used: persons, for example in Article 14, and citizens, for example in Article 15, 16 and 19. And then it goes on to say, in fact, fundamental rights provided in our constitution are more elaborate than those found in the constitution of any other country. So right now we are establishing the fact that constitution grants fundamental rights. And in body part, what we have done is that we have taken the provision in the left column and then the exceptions on the right column. So if you remember, we talked in the structure. So if you remember that we discussed that we are going to use the table format for answering this question. We are going to demonstrate the provisions of the fundamental rights in the left column, and then we'll talk about the exceptions in the right column, which we have already discussed in basic concepts which are needed to answer this question. So continuing with the introduction, the line says, however, none of these rights are absolute and are subject to reasonable restrictions. So Article 14, 15 and 16 provide for equality before the law and equal protection of the law. But the exception given in Article 361 for President, Governor and members of Parliament violate the principle of equality. Then Article 15 talks about prohibition of discrimination on the grounds. Again, the reservation in the form of exceptions, for example, Article 15 Clause 6 and Article 16 Clause 4 are a violation of strict principle of equality, but although positive discrimination. Then moving on to Article 19, which provides for right to freedom of various kinds, but at the same time also provides for reasonable restrictions on each of these cases. For example, right to speech is constrained on the grounds of defamation, unity and integrity of India, relations with foreign countries. Similarly, Article 22, which provides for protection against arbitrary arrest and detention, provides for exception in the form of preventive detention laws. So these were the fundamental rights with exceptions, but there are other exceptions also. For example, we have discussed the emergency provisions given in Article 358 and 359, which provide for restriction on right to freedom during emergencies and suspension of enforcement of fundamental rights. Similarly, Article 31C talks about suppression of Article 14 and 19 by 39 and 39B. So you saw that how we were able to demonstrate the fundamental rights as well as exceptions, which is basically that Constitution in one way gives us a lot of fundamental rights, but the Constitution puts so much restrictions on each of the fundamental rights. So it basically like it is giving the fundamental rights with one hand and taking them with the other. And finally, moving on to the conclusion, which says that as we can see, most of the fundamental rights are subjected to various exceptions, restrictions, qualifications and explanations. Hence, a lot of thinkers have commented that the Constitution of India grants fundamental rights with one hand and takes them with another. So you can see that we have substantiated the question statement. So if we put the sample answer to the test, we see that it has introduction, which was relevant as it talked about the fundamental rights. Then it had the body in the table form, in which on the left column there were rights and on the right column there were exceptions. And then finally the conclusion substantiated the question argument. So this answer is complete. Then we use the style which is known as table format of answering. This is the style which is usually used to answer the question where you have to draw the comparisons. And finally the language was simple and it was within the word limit of 250 words.